Ready for dictation, start. Whether the plaintiff has no cause of action to file the present suit, whether the plaintiff has not come to the court with clean hands and has concealed the material facts, whether the suit of the plaintiff is barred by limitation, whether the plaintiff is stopped from filing the present suit by his own acts and conduct. The trial court accordingly came to the conclusion that the agreement in question as such was not a validly executed document, and there was a doubt as such regarding its authenticity, and keeping in view the earlier agreement dated 9th August 2005, it directed refund of Rs 1,55,000 along with interest at the rate 10% per annum from the date it was borrowed. Para. Accordingly, it was held that in the suit for specific performance, there was a discretion with the court that the bargaining power was to be kept into consideration between the parties. Appellant defendant did not file any first appeal against the order of refund as such against the said judgment, and decree dated 23rd March 2012, the lower appellate court, as noticed, has allowed the appeal for specific performance of the agreement dated 6th March 2006. However, a perusal of the judgment would go on to show that the court below has only taken into consideration the agreement dated 9th August 2005 and come to the conclusion that the same was antedated. It took into consideration the report of the Deputy Works Manager, whereby the age of the stamps affixed on the agreement were taken into consideration. It was noticed that the stamps were of the year 1978 in one case, and in the other case the stamp was of the year 2006, whereas the agreement was of the year 2005. Resultantly, it was declared that the said agreement was antedated, and it was held that it was prepared by respondents number 1 and 2 in collusion just to discard the claim of the present appellant. Therefore, the appeal was allowed as noticed above. Unfortunately, the lower appellate court failed to take into consideration that it was also to record a finding on the correctness of the issues framed inter se the parties, and whether the plaintiff's suit was liable to be decreed on the ground that a valid agreement had been entered into between the parties. Para. As noticed, the plea taken is of fraud as such on account of a loan having been taken, and the judgment under appeal as such does not show that there was any discussion on the agreement to sell dated 6th March 2006 regarding the witnesses who had as such attested the same, along with the scribe, the readiness and willingness as such of the plaintiff, and whether the plaintiff was stopped from filing the suit, and whether the issues had been rightly decided by the trial court. The lower appellate court, being the last court of facts, had to necessarily give a finding on all the said aspects, which has not been done. Para. Learned Senior Counsel for the appellant is well justified in submitting that the court had expended its energy more towards the agreement dated 9th August 2005, which was subject matter of another civil suit, and has not given due attention to the agreement dated 6th March 2006. Counsel for the respondent is in no position as such to defend this aspect of the impugned judgment. In such circumstances, this court is of the opinion that the issue deserves a fresh relook by the lower appellate court. Accordingly, the present appeal is accepted the judgment and decree dated 4th August 2016. Stop.